Okay, so we're calling pages 41 to 72, Myles Hunwardsen et al. Versus Affinity Lifestyles et al. Case 831543. So let's start first with counsels for plaintiff here in court first. Mr. Parker, would you like to make your appearance?
Of course, Your Honor. Good morning again, Your Honor. Teddy Parker on behalf of Plaintiff Sosa.
Pepperman, is that, I don't see you audio-visually. Can you put yourself on audio-visually, please? There you go. Would you like to make your appearance, please?
Yes, Your Honor. Thank you. Good morning. Eric Pepperman for plaintiffs.
Okay, next we're going to go to Hannah here in court, please.
Yes, Chad Fears on behalf of Hannah Instruments, Scientific Instrument, in the Scientific Instruments, U.S. and International.
Thank you. Do you have anyone else remotely that you need to introduce? Or no? Okay. Milwaukee Instruments. Go ahead, please.
Elizabeth Lowell on behalf of Milwaukee Instruments.
Okay, and on behalf of Terrible Herbst, please. ETT1 DBA Terrible Herbst, please.
Yes, this is Trevor Everett on behalf of ETT1 Terrible Herbst.
Okay, we've got some more individuals. Of course, remember this is subject to a media request, so there is appropriate recording, but it looks like I might have a couple more counsels who wish to make appearances. So, Mr. Fresch, did you need to make an appearance?
Yes, Your Honor. Elaine Fresch on behalf of Real Water.
And who else do we have for Real Water as well?
This is Jim Cavanaugh for third-party defendant, Real Water of Tennessee.
Thank you. Do we have anyone else for Real Water in their defendant category that needs to make an appearance? And remember, you need to keep yourselves on remotely, audio-visually the entire time, please. Remember, that's the only way the court granted. FYI, that's what the new rules are anticipating too. So, sorry, Ms. Fresh, go ahead, please.
Oh, yes. Sorry, Your Honor. Elaine Fresch again. Mark Love, my partner, is here. He's the one. Okay.
You just you cut out as soon as you said, Mark Love, my partner, then you cut out. So I did not hear the end of your sentence.
Sorry. He is appearing because we have the motion for the pro hac vise, but he cannot make a formal appearance yet because he's not.
Okay.
I just wanted to alert you. He was.
Is that today too? Check that, please. Okay, and it looks like we've got a couple more names. And remember, Mr. Pepperman, we do need you audio-visually the entire time. We need to make sure that way we can keep track of everyone who's speaking. Okay, Ms. Frister, did you need to make an appearance? Are you just observing, or you want to make an appearance? I'm just going by the names at the bottom of the boxes. Okay. MK, do you need to make an appearance, or have difficulty reading that one? Okay, maybe not for neither. Okay, so at this juncture, folks, we have a couple of motions which I think are going to be moot, but I just wanted to keep them on there. I was going to ask you a couple other questions. So first, we had originally had the motion for leave for supplement, plaintiff's motion to strike, which was document 590, document 586, and so we understand, is that going to be moot in light of something else you're about to tell me?
Yes, Your Honor. Teddy Parker again on behalf of the plaintiffs. Your Honor, the motion is moot. We've been able to reach an agreement with both Hannah as well as Milwaukee. I think Mr. Fears here will confirm the same. So it's unnecessary at this point for us to supplement the motion to strike.
Okay, and that would be both of your motions, which were both document 593 and 586. Is that correct?
That is correct, Your Honor.
Okay, so those, are we treating those as moot or withdrawn? How would you like them?
Your Honor, we'll consider them as moot.
Okay, we'll treat each of those motions as moot. The court need not rule. At this juncture, next, there is Mr. Love. What date is Mr. Love's motion on? We were trying to find it, and for some reason it did not look like it got specifically set.
Your Honor, Elaine Fresch, at the last hearing, it was set for the 28th, but then we had a notice that it was being set for today. So hence, that's why we both are appearing.
Okay, which is what we were trying to do, but for some reason it didn't get, sorry. you got the notice from us, but somehow the clerk's office, which is absolutely wonderful, and you can appreciate, in this case, you may have filed more than just a few things in the last week or two. So missing one item, but that's why I was asking. Okay, so then the next matter we go to is the Pro Hoc Vice. For Mr. Love, the court did not receive any opposition. The court was inclined to grant it having all the appropriate Supreme Court rule provisions set forth therein. Counsel for movement. Ms. Fresch, anything you wish to add?
Nothing at this time, Your Honor.
Okay, Mr. Love, is there anything you want to add? You want in, right?
No, Your Honor, but it's nice to be able to speak now, so thank you.
Okay, I didn't, like I said, just because there was, I guess, a little bit of a clerical issue down in our wonderful clerk's department. Did anyone file an opposition that somehow never got set? I'm just walking through this. I didn't see any, but since we had that one little issue, I'm making sure. On behalf of plaintiffs, there was nothing, correct?
Nothing that we filed, Your Honor.
Okay, on behalf of Hannah?
Sheffier's on behalf of Hannah, no.
And on behalf of Milwaukee?
Sorry, Your Honor. No, Milwaukee did not file an opposition.
Okay, thank you. Real Water, Tennessee?
No opposition.
Okay, ETT 1, Terrible Herbst?
No opposition.
Okay, it is granted. It is so ordered. We need your order, please, and then we get your NEL, and that was, thank you, document 593, like I said. Don't know how it didn't get on here, but we're all good. Okay, that was today's matters. Now, here's a question for you all. The court received late last night, there was, well, two things. As you know, there's a motion for good faith settlement set for tomorrow, which the court could hear, but I was going to, ask all the parties, since I have you all here, and the time for an opposition has passed, do the parties wish me to hear it today, or shall I see you again tomorrow? I was going to circle around and get people's positions. Go ahead, counsel for plaintiff.
Again, Your Honor, Teddy Parker on behalf of plaintiffs. We have no opposition to having it heard today.
Do you like it advanced under EDCR 2.23?
Yes, Your Honor.
Okay, counsel for one of the movements, Hannah?
Sheffier's on behalf of Hannah, we have no objection of moving it up today.
Do you want it heard today, or do you
Yes.
want it to? I mean, I'm just trying to do it to convenience you all. If
Yes,
you,
I'm fine doing it today.
okay, thank you. Milwaukee Instruments.
Yes, Your Honor, we have no opposition to your hearing it today. Thank you.
Would you like it heard today? Like I said, everyone, I'm doing it only if you want me to. It's up to you all. I've got other hearings tomorrow anyway, so if it's more convenient for you all to have it heard today and everybody's in agreement, then I can. If you don't, let me know and it'll stay on for tomorrow. So, Milwaukee.
I would defer to Hannah's counsel as he has taken, the time to go down to the court today.
Yes,
Counsel.
I'm fine advancing it today if there's no opposition from any other parties.
Okay, thank you. Let's circle around to everyone else. Mr. Pepperman, since Mr. Parker spoke on behalf of plaintiffs, I understand you do represent some different plaintiffs. Do you wish to be heard?
No, Your Honor, I would request that we hear the motions today to save everyone and the court some time.
Okay, Mr. Cavanaugh, on behalf of Real Water of Tennessee.
I would agree with Mr. Pepperman, and I think it's a good idea to move it to today.
Ms. Fresch, on behalf of Real Water. Or should I go to Mr. Love, or both of you? Whoever's speaking, go ahead, please.
I'll speak, or we're fine to have it heard today as well.
ETT 1, Terrible Herbst.
Yes, we're also fine having her today.
Okay, I think I've gone through anyone. Does anyone not have an opportunity to speak? If so, please let me know. Okay, well, based on that, so what I understand is going to happen, the standards for motion of good faith settlement, there's a separate request on OST which hasn't yet been heard, which the court was going to also advance to today, because that really involves an analysis of the court of Part 7 of the Supreme Court rules, and particularly Rule 3 therein for sealing and redacting. The court was inclined to grant the OST and was inclined also to advance that pursuant to EDCR 2.23. I was inclined to grant it as unopposed under EDCR 2.20. Just 1 second. We had somebody else just join. Ms. Hernandez, did you wish to be heard on something in this case?
Good morning, Your Honor. Cindy Hernandez. No, I did not. I was just listening to monitor status.
Okay, no worries. I just knew I want to make sure. Okay, so With regards to the pending motion for good faith settlement on behalf of Milwaukee and Hannah Instruments, counsel, as you can appreciate, one of the standards is the court actually has to review in camera, at least, the amount. Do you by chance happen to have that for the court?
Yeah, Chad Fierce on behalf of Hannah. Yes, I do. I just showed it to Mr. Teddy Parker.
Mr. Parker, do you confirm it's the amount that's
It is,
agreed
Your
upon?
Honor. Thank
Okay.
you so much.
Mr. Pepperman, are you requiring to see it?
No, Your Honor, I concur with Mr. Parker.
Okay. Did the only non-individual, impacted entities would be Real Water of Tennessee, and ETT. Did any of them have the benefit of being able to see these numbers?
They have not, because we haven't filed it under seal, but we did put in our motion to call me or to get the numbers, and no one has called me.
Okay, well, let's walk. Since everyone said it was fine to hear it today, I'm going to let you walk through your process. The court's going to review this, and then I'll see if anybody has a different viewpoint. Thank you so very much.
Your Honor, under the 5 points, we believe that the amount of settlement supports a good faith settlement given the amounts that are being given to the 5 plaintiffs. How they are allocated are based on both the time they consumed real water products and the degree and severity of their injuries. Insurance policy limits, there is an ongoing dispute between one of Milwaukee and their insurer, and this is close to the policy limits on that as we've talked, so another in favor of good faith settlement. The financial condition of settling defendants is not an issue here. We reached this not in duress, but to settle this case in this trial. And the existence of collusion, fraud, and tortious conduct, this was an arm's length negotiation between Plaintiffs' Counsel and us, and we actually did negotiate, going back and forth and talking about different issues about the settlement amount.
Okay. Well, let me circle around to everyone else because nobody raised any opposition or any contention about not having the numbers available. Everyone wanted me to hear it today, but let me make sure before the court gives its own impression. So, Real Water. Do you have it?
We do need, Your Honor, this is Elaine Fresch again from Real Water, for the record. We do need to receive and obtain the numbers, but if counsel agrees that we can call them later, I anticipated we didn't really have an opposition to it, but we do want to know the numbers. But if counsel agrees that we can call him later and get those, I'm okay.
That is agreeable, Your Honor.
Okay. So is your request that the court grant it today, but subject to any approval for form and content, be that you have an opportunity to see the numbers before the order is submitted to the court? Is that what you're requesting or something different? Go ahead, please.
Well, Your Honor, because my co-counsel, Mr. Adu, is not present, nor is Mr. Kaufman, and they have been involved with this case much longer than my office has, because we've only come in the last 30 days. I would prefer if we can receive the numbers prior to an order being signed, just to ensure that I am not aware of something that Mr. Adu knows that would impact any of this.
Right. What the court was asking is if you're requesting that the court make its oral ruling, Division of Family Services, Rush versus Clark County, today from the bench, as all the parties requested, but that you receive a copy of the proposed order, and then when you do your email confirmation about whether or not you're approving the form and content, that you would take the weathering order, that before that time frame you would reach out to counsel for Hannah if you wish to receive the numbers. Would that meet your needs?
That would meet my needs.
Okay. Is that agreeable to counsel for Hannah?
Yes.
Is that agreeable to counsel for Milwaukee?
Yes, Your Honor.
Okay, so that's Real Water. Now let's go to Real Water of Tennessee. Go ahead, please.
Your Honor, good morning. I would make a similar request as to the amount with regard to the individual plaintiffs involved in the settlement, so we can have information for offsets in the future, potentially, and I would like to be able to call Mr. Pierce and get that information if that's available.
Okay, so would that be the same thing that the court just said a moment ago was the request of real water, so that you can just address it before you get circulated to you for your approved as to content and form?
AAA emergency contact.
Yes, Your Honor.
Okay. Mr. Fears, does that meet your needs on behalf of Hannah?
This is Mr. Fears. Yes, it does.
That meet the needs of Milwaukee?
Yes,
Ms.
Your Honor,
Lowell.
it does.
Thank you. Does that meet the needs of plaintiffs? I should have said it for both. I thought I had mentioned last time.
Again, Teddy Parker on behalf of plaintiffs, so said does, Your Honor.
Thank you. Mr. Pepperman, do you wish to be heard as well?
It meets Eric Pepperman for plaintiffs. It meets our needs as well, Your Honor.
Okay, thank you. So you can appreciate I'm now going next to ET&T Terrible Herbst.
Yes, I would agree with what's been said, as long as you can discuss with counsel and see prior to the order.
Okay. Does anyone else wish to be heard? We have a new phone number that just popped up that ends in 007.
Your Honor, this is David Spurlock. I'm just observing.
Okay, you're more than welcome to observe. You're right. Okay. So, but Mr. Spurlock, refresh the court's recollection, please. Do we have an NEO on your resolution yet? Or I'm just trying to...
Excuse me, Your Honor.
Do I have the notice of entry of order yet on your motion for good faith?
I know it's been prepared. I don't know if it's been submitted yet. I will make that determination. I will make sure it's in there to you immediately.
No worries. My question was actually for the other reason, is to see if you needed to sign off. Before you came on the line, the request was to advance to today the motions for good faith settlement on behalf of Milwaukee and on behalf of Hannah, right?
I would have no objections, Your Honor.
Okay. Then the other request was that it be granted, but that some parties had requested to be able to know the amount of the good faith, since that was not specifically put in the public document. The court granted the redaction, that they have that ability to reach out to Mr. Fears prior to doing the approved as to form and content when the order gets circulated. The reason why I was asking for you, whether we had your NEOs, whether I should be asking you that same question, or...
Your Honor, David Spurlock, I would certainly have no objections to what counsel has agreed to at this point.
Okay, thank you. And you can confirm whether they've got an NEO or you're circulating to them. I'm sure you all can do that right without the court's assistance. You can look through the docs. Does that meet your needs, Mr. Fears, as well?
It does.
Does that meet your needs, Mr. Parker, on behalf of plaintiffs?
It does, Your Honor. Thank you.
Mr. Pepperman, does that meet your needs on behalf of plaintiffs?
Yes, Your Honor. Thank you.
Thank you. Is there anybody who, in any capacity, would still like to be heard? If so, please let the court know. No. Okay. So here's what we're going to do. As far as the order shortening time that's currently in the box, because of when it came, based on everyone's agreement that I could hear these matters today, the court is going to sign that OST. I'm going to put it on for today. Now, you appreciate that meant there wasn't the one judicial day, but I gave everyone the chance. This is the last call. If anybody has any issue on the sealing and redacting, I'm fine to put it for a different day. Once again, this is just to accommodate all the parties if you want me to be accommodating to you. I'm pausing for a second to see if anybody wants me to set it for a different date. Oh, okay. So then what I'm going to do is I'm going to, as agreed to by the request of all the parties, is I'm going to sign the OST. We're going to put per the request of the parties in open court or some language to that effect, right? It was heard today. It was advanced today. Granted, the court already had a chance to review it under the Supreme Court rule, so it met all of those standards. The court's also going to probably put a little, when you send the proposed order, just please make sure you include a line that you provided the court a copy in open court for in-camera review of the numbers, and that you agreed to provide the amounts to any of the remaining parties that requested, okay, based on what was stated here in court today. And that way we can get that one taken care of. So right now that's going to be a two-step process, right? I'll sign the OST and then do it for today, but for the actual order granting it, please ensure you've got an appropriate language for Supreme Court rule compliance. The motion for good faith, it meets the standards of the NRS, it meets the standards of the applicable case law that's not only cited in the pleadings, but also discuss many of those factors here in open court. So it was advanced pursuant to EDCR 2.23, the motion for good faith settlement for Milwaukee and for Hannah. It is granted in accordance not only with EDCR 2.20, but also on the merits. And on the merits, as the court started to mention a moment ago, they said it meets the statutory standards, meets the standards of Doctors versus Vincent, MGM factors, all the various case laws and their progeny that have been cited in the pleadings, and walking through all of those factors here in open court, plus the inclusion of providing me the in-camera Exhibit A, which actually had the amounts for the court to consider as well. It is so ordered that takes care of each of those. That's what the court sees was on for both today, and then the request of the parties, what was going to be on for tomorrow, and the other matters. So, Counsel for Hannah, you're standing. What else can the court do for you?
Part of that motion and agreement we had was to either hold the motions that are specific between Hannah and Milwaukee and plaintiff, either in abeyance or withdrawal. And the other part was not, we had a hearing last week.
Yes.
We made an oral pronouncement, and part of our agreement is to ask not to have that reduced to writing.
Sure. So that's one of the things the court was going to ask. With regards to certain of the pending motions, what I'm going to need is I'm going to need a stipulation from the parties to articulate specifically what you're requesting, because it was, appreciate it was kind of said more in a general sense, right? But remember, part of plaintiff's motion did not only apply to your two clients. So I need a clear how you're going to break that down, meaning that the court is going to do request not during an order only on a part of a motion and not the rest of the motion, right? Or whether or not you're going to view the motion, since it's not yet been effectuated, into a written order some other way. That's why it's going to make more sense to have clarity of specifically what you're asking. From the first standpoint, the request to hold in abeyance the deadline of Milwaukee and Hannah, is there really any need to do so in light of the court granting it today? Are you concerned about the intervening time frame, or why don't you walk me through what the question is, because like in the issue is, right, so that I clearly respond. I've addressed the order portion, so let me address the motions portion.
So there is that two-part. How do we address the order? We can talk with plaintiffs on that. The other part was we have a bunch of pending motions, and how to make it easier for the court to know these motions are not going to be heard because of the settlement.
Okay.
And my proposal was I work with plaintiffs' counsel, and we can get a stipulation, which you have, and to say these motions are being withdrawn because they only deal with plaintiffs or Milwaukee.
Yeah, that's what we've done in the past. We've done that, and it's easier when you do that you give the title of the motion, right? And then do the document number, and then also to the extent that Hannah and or Milwaukee Instruments has done joinders to other parties' motions, that you put those in as well, right? And then that's kind of tying back to what the court had said, the status check, that it would be helpful if you all want to, right? It's better to give us a letter, right, of the remaining motions that are to be heard. And if you are requesting jointly a particular order to hear said motions, then the court can do so. As you notice right now, there was one motion that was from the 5th, but that now went to the 13th or 14th. The clerk's setting the special setting on the 13th and or 14th.
I'm putting everything on.
Okay.
Them around.
Okay. So right now they're mostly up. They should be going on the 14th, and then we'll move some to the 13th. Reason being is if there were some ones you wanted to be heard in the first category, right, to be heard on the 13th, then we can move them the 14th. We were anticipating a letter based on the time frames I gave you at the last hearing, right? And I appreciate that maybe a party may not want to do that. If we're not, then we're going to look at them ourselves, as we said, and I will decide which ones get heard on the 13th and which ones get heard on the 14th, which for Hannah and Milwaukee really should not affect you, because presumably you'll get me an order and an NEO before that date. And yes, it's helpful to put in the stipulation that you're specifically withdrawn and the document number, because then what we do is we have the clerks, usually that has to be done wonderfully in our department, but they just will go through a checklist, right, of everything that you put on there, and then we can get those removed, including all the joinders, okay? Same thing with plaintiffs, to the extent that, you know, it can be the same stipulation, plaintiffs' motions that are impacting. If there's a motion that is, remember those of you who may have filed non-substantive joinders and these motions are withdrawn, the court has to evaluate whether or not it still goes forward if there's a non-substantive joinder. So, or if there's a motion done on behalf of multiple parties that only one party still exists, we just need at least that heads up in the stipulation, okay? yeah, the court really decides in the non-substantive joinder component, right? And that's straight under the rules of the DCR.
Your Honor, if I hear you correctly, I think what would help the court is, one, the letter of what's going forward, two, a stipulation of what's going to be withdrawn.
Yes.
And I'm just thinking, because I was just looking at this yesterday, there are other motions that affect other defendants that would become moot if we're not in the case. And so I will try to get a stipulation circulated to, and I'm just talking about a motion limiting, I'll give you an example, Real Water, one of our experts. If we're not in the case, the expert's not coming to testify. But I want to run that past Real Water.
Remember, take a good look at the EDCR, right? If there's rules on who filed the motion, or if it's multiple parties who filed a particular motion, people did or did not file a joinder, and if that joinder was substantive or not. And so, but yes, from an organization, we much appreciate the information of which ones are specifically withdrawn, right? Your joiners. For example, if Hannah did motions on their own, they're likely withdrawn, right? Milwaukee on their own. If Hannah or Milwaukee did joinders to other parties' motions, generally, historically, those have been withdrawn. To the extent, I don't believe I've seen any joint motions with Hannah or Milwaukee and any other defendant or third-party defendant where you did one jointly. But if that is the case, then we just would need to know, for example, remember the other week we heard a partial motion. It was both on behalf of AT&T and Costco, but Costco had resolved, so it only went forward on behalf of one of the parties. So it's better to give us a heads up if that's intended to go forward on another party. If someone chose not to file a joinder to one of your motions, then the rules say what happens.
We will do that. I'll talk with Real Water because they joined in one motion that plaintiffs filed that I'll
Thanks.
talk with them.
Yes, some of those details may be party specific. I try and give just the general what people have done historically. So usually the stipulation comes first and then the letter comes afterwards because it gives you a chance to speak among yourselves on what's left. And if the parties want to have something in any particular order, like I said, we don't get a joint letter in a particular order that you want the motions that are left, then we will determine how they get heard. We're just trying to provide you that opportunity if it's more helpful to the parties.
Thank you, Your Honor.
Did I answer your question as much as I can for today?
As much, it gives us enough guidance that we can get something to you to make sure the court's burden is lessened with this. Yeah.
It was similarly done in opioids, it was similarly done in DOT. It's been done in a lot. Yeah, a lot of your colleagues have done it in a lot of the other cases. We've done it in tons of different construction defect cases. So it's just clear, here's what we would like, okay? And it's also helpful, remember, to give the amount of time you think you need for oral argument. That really doesn't apply to you. That really would be applying to everybody else for the remaining motions. We're not saying you necessarily will have that entire time, but it gives us a ballpark to try and schedule out the different days, right? So that we ensure that we get everything heard, but at the same time ensure that people have the priority ones done and give the time more allocated to the ones that people think are going to need more time. Okay?
Okay.
Okay. Is there anything else from Hannah other than wish you a great rest of your day, week, and a happy Thanksgiving? Anything else from your end?
Champions, on behalf of Hannah, there's nothing else, and wish you the same.
Thank you. Milwaukee Instruments, anything else from your end?
No, Your Honor. Thank you very much.
Plaintiffs here in court.
Nothing from our end, Your Honor. Thank you again so much, and you and your staff have a great Thanksgiving holiday.
Appreciate it. Mr. Pepperman, on behalf of the other plaintiffs.
Nothing except wishing you and your staff happy Thanksgiving. Thank you, Your Honor.
Appreciate it. Thanks so much. On behalf of Real Water, whoever's taking that one, go ahead, please.
Nothing else, Your Honor, except happy Thanksgiving as well.
Appreciate it. Thanks. Real Water of Tennessee.
Nothing else, Your Honor. Happy Thanksgiving.
Thank you. ET&T DBA Terrible Herbst.
Nothing further. Happy Thanksgiving.
Appreciate it. Thanks so much. Mr. Spurlock, if you wish to say anything else, I think you were taken care of, and I did not, right? Is that correct?
That's correct. I'd like to wish you and the court a very happy Thanksgiving.
Appreciate it. Thanks so much. I think anybody else need anything? If not, we're going to conclude this matter. Like I said, wish everyone a great rest of your week and a very happy Thanksgiving. Thank you so much.
Thank you so much.
Take care. Bye.